Here we are, though. We're live, which is so exciting. Hi, Rachel.
Hi, Archie. How are you?
I'm doing okay. How are you doing today?
I'm doing well, thanks.
Good. And welcome to all of you who are joining us. We're excited to have you. So folks know my name is Archi Pyati, and I'm the CEO at the Tahirih Justice Center. Rachel, do you want to introduce yourself?
Sure, I'm Rachel Sheridan, Litigation Counsel at the Tahirih Justice Center.
Awesome. Thank you for being with me. So what I want to share really briefly with folks at home who are tuning in is that the Tahirih Justice Center is an incredible organization. It's a national nonprofit organization that provides free legal and social services to immigrant survivors of gender-based violence. Now, some people don't know why we do exactly this. Well, you should know that there are across the country hundreds, thousands of individuals who are experiencing gender-based violence all the time. These women and girls predominantly are out here trying to get to safety, trying to get protection. For immigrants in particular, that pathway, which is already so hard, can be even harder. Immigrant survivors sometimes don't have access to basic things like healthcare, access to things like long-term help with housing. Shelter time even can run out for some immigrants. The ability to work legally is not possible for many immigrants, which means that they can't provide for themselves and their children. These factors can often be push factors into additional victimization, additional opportunities for re-traumatization. It's very dangerous and very scary. So we at the Tahirih Justice Center focus on providing legal and social services that we believe lay a couple of bricks on that long road towards safety, healing, and protection for immigrant survivors of violence. So today, what I want to do is offer a little bit of a window into a very unique part of the law that is kind of hard for a lot of us to understand. So you should know that I'm a lawyer. I went to law school many moons ago. I was trained as a lawyer. I represented individuals who were seeking asylum and other kinds of protection in the US. But it's been a few years, and at this point in the current seat I hold at Tahirih, I sometimes find that there are big changes in the law that happen that I say, wow, that seems important, but I don't quite know why. And Rachel is one of the incredible experts here at Tahirih that I turn to help me understand and to explain what's going on in the law and why should I care as somebody who's here to support immigrant survivors of violence. So today, Rachel, we're going to dive a little deeper, and I'm going to ask you to work with me. We're both going to need help reminding each other not to use too many acronyms and to make sure that we are explaining the law as best we can for those individuals who care so deeply but may not know about a couple of big things that are happening that aren't making it into the news. So Rachel, why don't you go ahead and talk to me a little bit about the cases you want to talk about today?
Thanks, Archie. There are two big cases that came down at the end of the term, at the last Supreme Court term, which ended in June. So in May, there was a decision called Patel versus Garland. And then in June, another decision came down called Garland versus Aleman Gonzalez. Both of these decisions are really important because they both represent a restriction on protections for immigrants in federal courts. They do so, though, in very different ways, but I think they deserve a little more attention than they have gotten lately. So I'm glad we're talking about these.
Awesome. Well, let's take them one at a time. I think it would be helpful to kind of break them down a little and hear what their impact really is. So let's start with Garland v. Patel, or you said Patel v. Garland. Can you tell me a little bit more about that case?
Yeah, so the facts of this case bear a little bit of exploration. I think they're pretty helpful to understand. So Mr. Patel has been in the US since about the 1990s. And a few years ago, he went to renew his driver's license in the state of Georgia. When he went to renew and fill out that form, he accidentally checked a box stating that he was a US citizen. Now, he wasn't a US citizen. He's an immigrant. He didn't have a current status at the time. Afterwards, he applied for adjustment of status. And the immigration judge saw that he had mistakenly checked this box on his driver's license application and said, "This looks to me like a false claim to US citizenship." Mr. Patel said, "Oh no, this was an honest mistake. I knew I wasn't a US citizen and I wasn't trying to get any benefit here. In fact, there isn't any benefit to get here. You don't have to be a US citizen to get a Georgia driver's license." So there's actually no way to conclude reasonably that this was a false claim to US citizenship.
Yeah.
Well, the judge completely disregarded this testimony, disregarded his representation, and denied adjustment of status on this basis, saying he was not eligible for the relief. It was really unfortunate, and the Board of Immigration Appeals affirmed that decision. Well, this is a clear error, and the reason we know it's a clear error is that Justice Neil Gorsuch, in dissent, called this error both egregious and glaring. Yet the Supreme Court majority held that in cases like this, the lower federal courts have no jurisdiction to review these types of factual findings. So even though this denial of status is based completely on a factual error recognized by justices of the Supreme Court, Mr. Patel is totally out of luck. He has no chance at getting adjustment of status now.
Wow, what a huge consequence for such a completely, I mean, very human error. I could easily have checked. I often check the wrong box on things. I can't imagine having this kind of a lifelong consequence. Can you tell me a little bit more about why you think it would be important to have a federal court weighing in on this and being able to review a decision like this?
Yeah, I mean, what's happened here is really two mistakes, right? Patel made one mistake, and then the judge made another mistake. And the judge's mistake is one, it's a kind that can happen all the time. Judges are overburdened, they have huge dockets. Officers at the immigration agencies also have huge amounts of cases. We know that there are really severe backlogs at all the agencies. People have limited access to counsel to help them clear the record. There are language barriers. And sometimes there are even things like judge bias. All these things can result in serious mistakes in all kinds of applications. And always counted on the federal courts as the place to go to have these errors corrected so that we don't reach the kind of unjust result that we see in Patel's case. Well, now that avenue of relief has totally been foreclosed in these types of cases. So it's a really unfair and unfair result.
So really, you only get one shot. I mean, if the first judge makes a wrong decision, you're out of luck. I mean, that could be really consequential. Now, for our clients who are immigrant survivors of gender-based violence, as we said at the start, you know, what could the impact be for them? I think, you know, what I'm hearing from you is that for any immigrant, it sounds like Mr. Patel Mr. Patel, like so many others out there, could have a really lifelong consequential problem because of a small mistake. And then there's no federal court that could really look at that and overturn it. For individuals like our clients, why is this especially problematic?
You know, our clients face very significant hurdles in presenting their cases effectively and being able to really advocate successfully in court. Many of them trauma survivors. You know, they need more accommodation for coping with the trauma of recounting trauma stories. They have, in many cases, more limited access to counsel. They may have language barriers. So there are a lot of significant barriers that face our clients in particular. You know, some of the ways that this lack of the access to federal courts can affect survivors in particular is that many survivors are facing, you know, they're dealing with things like police reports against abusers or other types of bureaucratic records which can easily contain flaws or be read, be miscited. There are even cases of mistaken identity where records relating to the wrong person are added to the file. All of these are really critical actual errors that can make the difference between eligibility and non-eligibility. And when a federal court is not allowed to reach out and correct those kind of errors, you know, we can really be abandoning some of our most vulnerable immigrants to a lack of protection here.
That's really scary. I'm really sad to hear this. I'm so grateful that you're here to explain it, that here at Tahirih, where, you know, we are really specialized. I think some people out in the world look at us and think we're a very small, we take up a very small niche of the world because we focus so specifically on immigrant survivors of gender-based violence. But what they forget is that more than half of immigrants in the United States are women. More women who are immigrants are likely to experience gender-based violence than other women in the US. And so these changes to the law impact millions of people potentially. So while we're a tiny staff, the expertise that you hold is really critical, not just for the clients we serve, but for millions of others potentially. So I'm grateful to you for explaining that to me, which I really did not understand. Can we talk a little bit about the other decision, Aleman Gonzalez, now?
Sure. In Aleman Gonzalez, this is a very different situation. This is a case of a couple of people who were in detention pending their removal proceedings. And they went to the federal court and asked for certification of a class, so a group of people similarly situated, people who were all in detention awaiting their hearings and had been in detention for more than 180 days, 6 months in immigration prison.
That is
And
a long time.
yeah, and they were saying after 6 months, we're entitled to a bond hearing. You know, we should be able to post a bond and be released and await our removal proceedings outside of immigration prison. And the district court in California and the Ninth Circuit agreed that class certification was appropriate and a bond hearing was necessary under those circumstances. Well, the government appealed that decision to the Supreme Court, and the Supreme Court certified the question. Now, when you seek certification to the Supreme Court, you specify the issue that you want the court to review. And that they wanted the court to review is a bond hearing required for those detained longer than 180 days. And that was the question certified. But after certification, the Supreme Court reached out and said, actually, we want to brief an additional question, the threshold jurisdictional question of whether a class can even be certified for alleged violations of these provisions of the federal immigration laws in order to get an injunction to prevent the agencies from violating these immigration laws. And then the Supreme Court said, no, you can't get that kind of class-wide injunctive relief against violations of the immigration laws. The impact of this decision is that even if a court holds that our government is violating its own laws with regard to detention and removal proceedings, you cannot get a class-wide injunction prohibiting those actions from taking place.
Wait, so there's absolutely no way to stop the government from violating its own laws as a class if we know that there are a lot of people suffering the same kind of ill treatment by the government as it is breaking its own laws? There's no way to file a lawsuit and get relief from that.
You can't get a class-wide injunction for that. So there are other ways to get relief there.
Okay.
An individual who's in removal proceedings who has had their rights violated could get an individual injunction. So
right.
An individual prohibition against the government violating their rights, right? But that's not that helpful when there are so many people who are in the same position, who have very limited access to counsel. Remember, in this case, we're talking about people who are detained. That's right. Even harder a position to get counsel from than most immigrants, right? People with limited access to resources, limited understanding of the US court system. Sometimes there are language barriers. Again, these are some of the people who need the most support in navigating litigation and getting their rights vindicated, and a major important tool has just been taken away.
And litigation can be very expensive. I mean, I know you mentioned so many different barriers, but the idea that, you know, every individual is going to bring a lawsuit, I would think it would be against the desire of the courts too, because they're going to be sitting there potentially managing 300 lawsuits instead of one lawsuit that covered 300 people or more. So it doesn't sound that advantageous to have made a decision like this from the perspective of the judges either.
I think that's right. And a judge who has since looked at this decision has said exactly that this is a really inefficient decision. Yeah. And it really doesn't behoove the federal courts. I mean, one very important justification for certification of classes is that it really is in the interest of judicial efficiency to certify classes. It makes it a lot easier to make big corrections to big mistakes that apply to a lot of people. So that's a really important impact of the decision.
That's really significant. Have you seen any impacts on individual people or on enforcement actions or anything else since the decision came down?
Very soon after Aleman Gonzalez was decided by the Supreme Court, a decision came out of the Southern District of California that squarely interpreted the Supreme Court's decision. In that case, the judge had held that the turnback policy was illegal. And the turnback policy, as you know, Archie, but I'll explain for others here, is where the Border Patrol was prohibiting people from approaching the ports of entry to seek inspection and referral and have their asylum claims referred for adjudication. So the Border Patrol didn't even allow people to show up and say, I want to seek asylum. They prohibited them from approaching the ports of entry. The judge held that policy was illegal. The problem was, in the wake of Aleman Gonzalez, she found her hands tied. She was no longer able to issue a class-wide injunction prohibiting the government from implementing the turnback policy. So in that case, and her decision, by the way, is scathing and seems extremely frustrated in the way she talks about it. She says, now you can determine that the immigration agencies and the federal government have engaged in rapacious executive overreach, is her language. And there is really very little recourse at that point. So what she did in that case, she did what she could do, and that was she was able to issue an individual injunction for the one named plaintiff in the case for whom it really was appropriate. So one person got something out of that. And then she also issued a declaratory judgment. Now, in some cases, she might have, under other circumstances, she might have issued a vacator, which is basically like returning the regulation to the status quo ante. In this case, the policy had been rescinded by that time, so she couldn't do a vacator in this particular case. But she did these other two steps, and that was really the most she could do.
Wow. I mean, given that that's the most she could do, and she's a judge in the federal system, what do we think? What do you think on behalf of Tahirih and as a lawyer and an expert in this area can be done? I mean, you're talking about decisions that came down from the Supreme Court, the highest court in our land. What can we do about it as, if not, as lay people or as an organization with a policy team, and at the same time with direct services teams, all of whom are upset about this and want to make a difference and want to make change? What can be done at this point?
It's a great question. And, I think it's so important to recognize the significance of these decisions and how they really reflect a trend toward the restriction of immigrant rights and the protection of our most vulnerable by an institution that's really designed to protect our most vulnerable. That's how we've always historically regarded the federal courts in this country. It's disheartening when the Supreme Court makes a decision like this because they're interpreting federal statutes, and the only way to change that is for Congress to enact legislation that makes sure that the courts are empowered to protect our most vulnerable. So that's one step. We can ask our Congresspeople to fix this law by amending the federal immigration laws, and that's something that we would certainly work toward and hope for. And then the other thing that we can keep in mind is, as lawyers, it's really incumbent on us to continue to think creatively, to look at the statutes really analytically and see where else we have wiggle room, where else we can take steps to do novel and creative things to try to protect immigrant survivors and other vulnerable populations, and how we can get around these decisions to continue to protect people the best we can. Outside of the courts too, how else can we advocate? Can we work with members of Congress and the government to rescind these illegal rules and regulations and thereby also make progress in the protection of immigrant survivors and immigrant rights, broadly speaking? So I think what we have to do is we have to really stay nimble. We have to stay creative. And above all, I think we have to make sure that we stay hopeful.
Oh, that's beautiful. Well, I want to end there, given the fact that you just left us on such a high note. Thank you so much, Rachel, for explaining to me and to people who are listening some pretty, I would say, obscure Supreme Court decisions. They haven't received a lot of light of day or news attention, but they sound absolutely frightening and really shut down a lot of the power of the federal courts to help immigrants as they're navigating a really complicated system. Your intelligence, your wisdom, your expertise, your grounding in not only, given I know that your background is as a lawyer, but also and a litigator, but also as a direct service provider. I know that your heart is with the individuals who we're trying to help as an organization, with the individuals we can't possibly help every single day because we don't have enough capacity. And so I know that you come to this work trying to find ways to help even more people. And so for you to be willing to sit with me and explain these decisions and how they impact immigrant survivors and really all of us across the country, given what the Supreme Court has decided, is really, really helpful. So thank you so much, Rachel, for your time. And thank you to all of you for joining us and listening a little bit. I hope you learned something. I hope you understand a little more about what the incredible experts at Tahirih are doing. It's my joy and honor to work with people like Rachel here at Tahirih and to work with you in supporting the Tahirih Justice Center. So thank you so much.
Thanks, Archie.